Good evening, everyone, and welcome to the October meeting of the Wilmot Township Committee of Adjustment. I'd like to introduce the members of our committee, and with us this evening, in no particular order, we have Mr. Peter Rowe, Mr. Tyler Bowman, Ms. Louise Lalonde, and Mr. Steve Miller. Also with us, we have Mr. Andrew Martin, who is the Manager of Planning for the Township and is our Secretary Treasurer, as well as Mr. Cameron Miller, who is a planner for the Township and will be introducing all of our applications this evening. I'm not aware that anyone wishes to read the territorial acknowledgement, so I will do that. We have gathered in Wilmot Township on the traditional territory of the Neutral, the Anishinaabe, and the Haudenosaunee, and the Mississauga peoples. We also want to acknowledge the importance of the Dish with One Spoon Covenant, a peace agreement made between Indigenous nations before the Europeans arrived. It characterizes our collective responsibility to each other and to Mother Earth. We should take only what we need, leave enough for others, and keep the dish clean. By acknowledging this covenant and the First Nations, Métis, and Inuit peoples, we are reminded of our important connection to this land where we live, learn, and work together as a community. We are an independent body appointed by Wilmot Township Council, and we have the power to make minor changes to existing zoning regulations and to approve some changes to existing non-conforming uses, as well as to give consent. Each applicant will be notified in writing of the decision of this committee within 10 days, and with that decision will be instructions on how it can be appealed. Any decision made by this committee can be appealed to the local planning appeal board, who will then hold a meeting and make a final and binding decision. If the decision on a minor variance or consent is not appealed, it will become final and binding after 20 days from the date of this meeting. If the decision on consents is not appealed, the same will apply. As for the format of the meeting this evening, we will ask Mr. Miller to introduce each application. The applicant will then have the opportunity to come forward and add any new information if they choose to do so. Following that, any other member of the public can speak for or against the application. Committee members may then question the applicant and discuss the application. The committee will then make a final decision. Are there any situations of peculiar interest this evening from committee members? Seeing none, we can then proceed. Mr. Miller, would you introduce the first application, please?
Thank you, Mr. Roth. The first application is a minor variance application A14/22 concerning 59 Samuel Foster Court in Baden. So this application is proposing to allow an increase in the maximum allowable interior height of a second level loft of a building not exceeding 4.5 meters in height from 1.8 meters to approximately 2.4 meters. So in residential zones, the maximum height of an accessory building is 4.5 meters, but not exceeding 1 story. And in the zoning bylaw, if the interior height of a loft is greater than 1.8 meters, it is considered to be a story. So the applicant is proposing a garage in the rear of the property would have an overall height of less than 4.5 meters, but the second level loft will have an interior height of 2.4 meters, thereby technically making this a 2-story building. So the proposed building would have a similar massing and height of a building with an interior height that is less or equal to 1.8 meters. This application isn't proposing to increase the overall height of the building, just simply the interior height of that second level. Staff did not receive any concerns and are recommending that the application be approved.
Thank you very much, Mr. Miller. Mr. Martin, does the applicant or wish to address committee on this matter? You're not aware of it?
If they do wish to speak, if they want to use the raise hand option at the bottom of their screen. But I do see a hand here, so I will join the applicant.
Okay, thank you. Good evening, sir, and welcome to the meeting. Do you have anything that you wish to add for committee's attention?
No, I just wanted to be available if there were any questions, and just say that we've tried to respect the neighbors and other people in the property. I think by not having windows or anything on the second story that would look down on our other neighbors' properties or anything of that nature. And also just the consideration partially that I am 6'5", so having the increased ceiling height on the second level is kind of essential for me to just be able to be up there without having to do some serious bending over and whatnot. So that's just kind of the reasoning for it. So it's more of a functional space for me.
Okay, thank you very much. Mr. Martin, is there anyone else in the general audience that wishes to comment on this application? No? Okay, thank you. I'll turn it over to members of committee. Any comments, questions, or discussion of this application? No. Seeing none, I would ask then for a motion to be brought forward that we approve this application. Moved by Ms. Lalonde, seconded by Mr. Rowe. Is there any discussion on the motion? If not, all in favor? That motion is carried. Thank you very much. Mr. Miller, would you introduce the next application?
Thank you, Mr. Roth. The final application is a consent application B04/22, concerns 2372 Snyder's Road East. So this application is proposing to sever a new residential lot. So under rural infilling policies in the township official plan, council recently approved a reduction in the lot area and lot frontage for a lot within Zone 1 agricultural in September of 2022 to facilitate the creation of a new residential lot through a future consent process. So the applicant wishes to divide the property's frontage in half and retain a parcel of approximately 2,700 square meters, which would contain the existing home and sever a lot with an area of approximately 5,500 square meters. So the proposed severed lot would utilize an existing secondary access off Snyder's Road East, and the property is proposed to be developed with a single detached dwelling. So this application is simply seeking to implement this previous decision of council by creating the lots which were identified in the attached sketch. No concerns were received in circulating this application, and staff are recommending approval of the consent.
Thank you very much. Does the applicant or his or her representative wish to address the committee on this matter? Mr. Martin?
Yeah, I've joined the consultant to the meeting here.
Okay. Good evening and welcome to the meeting.
Thank you, Mr. Roth. My name is Nicolette. I'm with MHBC Planning and here on behalf of my client, Mr. John Dundan, and just here in support of the application and thank Cameron and Andrew for their staff report and their recommendation of approval. I just have one minor, well, hopefully minor request. Condition 5 regarding the requirement for parkland dedication are requested that condition be waived, just given the nature of this application, that it is just a creation of a lot for one residential unit, and it's a very large property, so it's a fairly onerous cost associated with parkland dedication, I'm just putting out that request on behalf of the client.
Well, thank you very much. That is the standard article in these consent applications. Mr. Martin or Mr. Miller, do you wish to comment on the applicant's request?
I could touch on that a little bit. I had been in direct discussions with Mr. Dundan regarding this parkland fee. As you had mentioned, this is a standard condition that we do impose when a new lot is created. The 5% amount in actuality, we come to a conclusion, an appraisal that we deem to be fair, and if there is a disagreement in that amount, then we can seek to go to a private appraisal to have those lands appraised for their value, fair value. But in this case, we did suggest an amount to the applicant of 10,000, and they did acknowledge that expense. So this is the first I'm hearing of this, but again, this is a standard condition. If Mr. Martin wants to add anything to that, certainly feel free.
No, I think what Mr. Miller's explained is correct. We, in this case, basically evaluated the property based on similar severances over the last number of years, and basically have used a value that's comparable to those lots. So regardless of the size, although it's essentially the same size as other properties we've dealt with similarly, we came up with the value that we feel is reasonable and has been used for other lots. But certainly the way the condition is worded, there's opportunity for discussion on that evaluation. If there was concerns, they would have the opportunity to retain an appraisal of the property, and the value would be assigned appropriately. But again, the Planning Act facilitates either the donation of land or cash in lieu of parkland, and this opportunity, cash would be the appropriate means, as a parkland is not, a park is not appropriate in this location.
Thank you very much, Mr. Miller. It has been my experience too that to eliminate article number 5 would really create a very, very slippery slope. And it is not what has been the standard, at least not in my experience, long experience, I might add. So anyway, to the applicant, the opportunity is there for some discussion on actually coming up with a very fair evaluation. So I'll turn it over to members of committee. Is there any comments or questions regarding this application? Ms. Lalonde.
Hi, I just have a question with regards to this 5%. Does our approval include that request, or our approval would be inclusive of how the document is written, how the application is written?
Mr. Miller?
The recommendation put forward by staff does include that. So we are considering the recommendation at the moment that would include that provision for parkland.
Which has been the standard. Any other, Mr. Bowman?
I would just echo Mr. Roth, your comments that I think we do want to keep that in, and in the larger picture, it's best to keep it moving forward. So I'd support keeping that condition 5 in there.
Okay. Any other comments? If not, I would ask someone to bring forward the motion to approve. Moved by Mr. Bowman, seconded by Mr. Miller. Is there any discussion on the motion? If not, all in favor? That motion is carried. Thank you very much. Thank you all for attending the meeting this evening. Mr. Martin or Mr. Miller, do we have any applications for the month of November?
We do have one application that's been filed. We're expecting at least 1 or 2 more. So we would look at November the 2nd, if possible.
Okay. Is that date good for most?
Yeah, it works for me. Thank you.
Okay.
I potentially have a conflict, but I won't know for a week or 2. So I think if the rest of the committee is available, we'll just stick with that date.
Okay. Mr. Miller?
Yeah, I'm good as well.
Good. And Mr. Rowe?
Works for me.
Okay, that works for me as well. So let's assume that it is November the 2nd. Okay, thank you. Before we adjourn, we need to approve the minutes of the last meeting. Would someone bring forth that motion? Moved by Mr. Rowe, seconded by Ms. Lalonde. Any discussion? All in favor? That is carried. Thank you all for attending. Stay healthy and stay safe. Good evening.
All right. Wish you all the same. Take care. Have a good night.